started. Are there any extra policies? Jason, we're going to get started. So Landry-Reyes from South Brooklyn Legal Services is going to lead us off for our next session. So take it away.
Okay. So I think I'm just going to stand for a minute to introduce myself and to get to know you a little bit, and then I'll sit down so you can see the PowerPoint presentation, which really is just the caption of the various pieces of the outline that I'll be going over. One of the great things about these CLEs is getting these really rich materials to take back with you, because you won't absorb everything I say today, nor should you be expected to. And it will be wonderful when you're actually, representing that tenant when you take that case, right? To be able to go back and refer to the cases and everything in the really rich outline. So this is this wonderful basics of defending non-payment outline that I will not take credit for having drafted solely myself, but it is the work of many wonderful attorneys from legal services and legal aid. And you'll get this by email, I'm told, tomorrow. Okay? But do not feel like you have to have it in front of you now. So I just wanted to give you a sense of who I am and what my background is and what I do. And then I'm interested, although Esther got to say a little bit about yourselves, about the kind of knowledge in the room and what I should be emphasizing. So I'm an attorney with South Brooklyn Legal Services. I've been a staff attorney there since 2004. I'm a 1993 graduate of Brooklyn Law School. I did what is now are you Brooklyn Law School? All right. I did an IOLA fellowship. Those don't exist anymore. But I worked for 2 years in neighborhood legal services in Buffalo, New York. I worked for a project called Project Dandelion, which was a fabulous project working with women who are transitioning from welfare benefits into work. And I did a lot of fair hearings, and I did some federal work, and I got a very good grounding in welfare law, which has served me incredibly well in the housing law arena. After my 2-year stint at the law school, I came back to New York, and I worked for a miserable year at a private disability law firm. However, it was an amazing experience in learning how to do SSI and SSD disability hearings. Also has served me well in the housing practice. After that, I worked for 8 years at the Elder Law Clinic, which is essentially a legal services office for elderly people at Brooklyn Law School. That clinic does not exist anymore, unfortunately. But it was a legal services office, and we did primarily housing work. We also did bankruptcy, we did Social Security work, we did some other kinds of consumer work. This kind of general practice, again, served me really well for housing work. So I guess my point is that wherever you're coming from in terms of your individual practices, you're going to be bringing to bear some pre-existing knowledge that is going to be helpful to you in taking a housing case. However, housing is a large substantive area of law. I'm going to be talking to you today just about basics of non-payment cases, but each one of the pages of this outline could be a training in and of itself. So forgive me if I kind of gloss over those areas, but I'm trying to give you broad-based knowledge from which to proceed. So that's me. I've been doing solely housing work since 2004 at South Brooklyn Legal Services, but it's a mix. It's a mix. I liked very much the sword and shield image that Esther was using. It's a mix of both affirmative and defensive representation. So we do a lot of non-payment and holdover cases, obviously. That's sort of the bulk of what we do as eviction prevention attorneys. But we also do affirmative litigation to prevent people from losing their housing subsidies, really crucial housing subsidies to keep them in those homes. So we do Article 78 proceedings to protect Section 8 terminations. We bring affirmative cases in state court and federal court on various issues that may have to do also with housing subsidies and other issues related to housing. We've been doing this, intervention in foreclosure proceedings on behalf of tenants to get necessary repairs. And interestingly, I've sort of developed this little kind of slice of knowledge about the rights of building workers in rent-stabilized buildings and others, who, the super is the person that all our tenants love to hate, but they're also a vulnerable group of people, many who are, underpaid and not getting their wages paid, and also getting at risk of eviction in a very real way. So it's been an interesting kind of cross-section of labor law and housing that I've had some recent experience with. If anybody wants to talk about that, I'm all excited about that, so I can talk about that. So I think, one of the other things that I was kind of surprised by was when Esther asked, who thinks that housing court work is awesome, and I raised my hand like a big geek, and nobody else in the room raised their hand. Well, I hope that you will find that it's awesome after we, give you some tools to go in and make it an awesome experience. What I mean by that is obviously not the power dynamic, right? We know that the power dynamic is awful. I mean that, of course, you're changing that power dynamic, and you are making a huge difference in that person's outcome. And that, to me, is proven, on a weekly basis. And it keeps me going, really, because it can be a very difficult practice. It's very draining, and especially the work we do, is emergency-based. And you can have a tenant come in at any stage. Really the most urgent stage where they're going to be evicted tomorrow, and you have to figure out whether you can do the order to show cause. And the very beginning stages where they've gotten a rent demand and the landlord's asking them for $21,000 and they don't know why. And for sure, this process is I don't think I need to draw the connections to gentrification for you. That was very nicely done in the earlier part of this program. But what you are doing is stemming that tide. And much of what I'm going to talk about in terms of the kinds of defenses that you can raise in non-payment proceedings, these have been developed over time by the effective representation of legal services and legal aid and other attorneys, the public interest attorneys representing tenants and building that case law. And now, we educate judges, and judges will say, oh no, wait, I know you can't do that. I went to a training that that organization gave. You can't sue the tenant for the Section 8 portion of the rent. And that's a really, really important thing because unfortunately, as we also know, the housing court process for selection of judges is not necessarily based on how much substantive housing knowledge you have. So you can end up with, standing in front of a housing court judge that that knows a lot less than you do. So it's important to be prepared, and that is what changes the power dynamic in housing court. Almost every single case that comes into my office, when I look at a petition, I can find 4 to 5 defects. They're sloppy, they're mills, they produce these things on forms, we're gonna look at some later. Thank God, because we were able to come up with ammunition fairly easily. But it takes some training of your eye to look for it. So that's what we're going to do. Okay, so enough about me. I'd like to just find out from the room, how many of you have actually represented tenants in housing court? Okay, a fair number. And would you say, how many have represented tenants in more than 5 cases? Okay, and more than 10? Okay. All right, good. So I have a sense. Okay. And how many of you are going to take a case after tonight's training? Awesome. Okay. Okay, so I think what I'll do now is, maybe unless everybody can see, should I continue to stand? You can see, okay? All right. So, again, these are broad strokes, but housing court is a real court. Okay, it is not an administrative hearing. There are rules of evidence apply. It's amazing to me how many people kind of think that it's not a real court. In fact, it is. I mean, what it is a summary proceeding. And so it's organized under the CPLR as a summary proceeding. And what does that mean? It means that essentially it's designed to move the property and the landlord back into his hands as quickly as possible. In that context, there is, and one of the biggest, I think, disadvantages is that one is not entitled to discovery as a right. So you have to move for leave for discovery in housing court, and you may or may not get it. In a non-payment proceeding, it's less likely that you will get discovery than it is in, say, a holdover proceeding. So I guess I'll just spend a second, because I think most people probably know the difference, but a holdover proceeding is going to be a proceeding brought against a tenant for an allegation of breach of lease or of some other offensive conduct like nuisance, or because the tenant's lease has ended and that tenant isn't rent regulated in any way or doesn't have any regulation governing their tenancy, and so the landlord is looking to evict them. That's a holdover proceeding. A non-payment proceeding obviously is about the rent. Okay. So the Civil Court Act is that portion of the law which created the housing part, and that includes both the HP parts and all the other courts. One part, the HP part, for tenants to bring actions against the landlords, something like, what, 10, 11 parts for landlords to bring actions against tenants. Civil practice, the CPLR applies, although there are provisions for summary proceedings. One of the things that lawyers need to rely on sometimes in doing this practice when they're having to get papers out very quickly is short service. There is an argument under the CPLR that the regular timeframes for motion practice do not apply, and CPLR 46, I think, allows for short service of a motion. We can talk more about that if you like. Okay, and generally the definition of rent stabilization that was given earlier was accurate. For the most part, rent stabilized tenants are in buildings that have 6 or more units. There are some exceptions. There are still rent controlled units. Rent controlled units are tenants who have been in occupancy, generally speaking, since prior to 1971. And they are statutory tenants. They don't necessarily have a lease, although they may have had a lease at one point in the 60s. But thereafter, they don't get leases from their landlord. They get statutory increases of 7.5% per year. And rent stabilized tenants, as you know, get the increases based on the rent stabilization guidelines board. And one of the things that I like to point out to landlords' attorneys regularly is that rents that we see sometimes that are extremely low are extremely low because the landlord has neglected the building and hasn't done what they could do to get those rents increased with the HCR. A 7.5% rent increase per year on a tenant's rent is huge, as are the guideline increases. So many times you'll see in rent histories that the landlord has just failed to register the rent, has taken a rent increase for years. We can talk about the implications of that later. In addition to rent control and rent stabilization, there are other regulations that govern tenancies in New York City. There's a myriad number of regulations that govern some tenancies in New York City, and it's what I think makes the housing practice in the city very dynamic. And so the state supervised and city supervised Mitchell-Lama apartments. They can be either rentals or middle income, low income co-ops. There's a whole series of regulations that govern that. There's federally subsidized housing. In Brooklyn, we have large complexes in Coney Island that are federally subsidized. There are tenants that have their rents regulated under those programs, so that you really, in looking at a petition, need to look at both the address, what's pled as the regulation which governs that building, and if in fact there are no regulations which are pled, do yourself the favor of checking that address and checking some history to see if in fact there are regulations that may apply. I've had clients come in with petitions where, if you looked at what the landlord was claiming the legal rent was, that a rent subsidy had expired. I'll have a tenant say to me, I don't understand, my rent was $400, and now they're claiming it's $1,200. Some of these regulations that govern low-income tax subsidies for federally subsidized units have expirations. They will, 10 to 15 years ago, they were subsidized, and those subsidies are expiring. or maybe they're not expiring, maybe the landlord is claiming they are, and in fact they're not. There are regulatory agreements that are going to be on file that you can check. Now, where can you look for this information? Is everybody familiar with ACRIS, that term? ACRIS, the Automated City Registry Information System. That is the place where all transactions on a property are going to be registered or should be registered. It would help you to track, the proper owner. When Jessica was talking about, who you're identifying as your parties in the case. It would help you to see if there's a regulatory agreement that would govern. There's gems in those regulatory agreements for rent setting and everything else, usually based on 30% of income. And there are some tenants who still have Section 8, and those are both individual vouchers, and those can be project-based subsidies. Section 8 is a housing subsidy, federal housing subsidy, that provides tenants with a rent at 30% approximately their income. There are no new Section 8s in the sense that Congress has not allocated new funds for new vouchers so nobody can apply for Section 8 per se. There are some exceptions, but they're rare. So these Section 8 vouchers and the project-based Section 8 apartments are very, very valuable. Having a tenant who is facing eviction for holdover, where they also have a Section 8 voucher, or non-payment, where they also have a Section 8 voucher, the risk is both obviously eviction, but also the loss of the Section 8 subsidy itself. Because if you're evicted for cause, your Section 8 can be terminated as well. There are programs that the city has implemented to try to keep people out of the shelters. One of those was the Advantage program. I don't know if anybody's familiar with that, but it's a program that's unfortunately over. It was a brainchild of Bloomberg. It was to get people out of homeless shelters, and it did that temporarily. But it also turned people in and out of really run-down apartments. It gave an incentive, unfortunately, to landlords to inflate rents and to fraudulently register illegally high rents because they were the cap under the Advantage program that they could get. So if the city was going to pay $1,070 for an apartment, but the legal rent for that apartment was $800, the landlord was offering a lease for $1,070. And they were charging the tenant, and the tenant who was coming in from the shelter had no idea that they weren't getting the deal. Yeah.
Say anecdotally, I've seen a couple of recent abuses where they put second bedrooms in closets and ripped out kitchens. I mean, just
yeah, absolutely. And many of those tenants don't even know that they're rent stabilized. So they have Advantage leases, but they're also rent stabilized. I had two people come into my office recently on our emergency intake who were both Advantage tenants. That's over. They're being sued in non-payment for the rent that wasn't paid by the Advantage program. And they have rents that are not the legal rents. And when I went to DHCR and got a rent registration history, and we can talk about how you can do that, noticed an $800 jump in the rent in both apartments at the same time, which was interesting that those factors, those stars all aligned. Also, there's a program called the FEPS program. It's the Family Eviction Prevention Supplement. It is the program that used to be called JIGETS. I don't know if anybody knows that name. And JIGETS was a lawsuit brought by the Legal Aid Society against the state which on a really amazingly crafty theory that the state had failed in its constitutional mandate. State constitutional mandate to keep families together by having an artificially low public assistance grant for families. And so by having this artificially low grant that nobody could actually rent an apartment for $283 a month, the state had, violated the Constitution. Interim relief in this lawsuit that was filed in the 1980s went on for decades, and that relief was a program called JIGETS, which has morphed into the FEPS program. To be eligible for FEPS, which is essentially a higher shelter allowance based on your family size, you have to have an active eviction case going on, and you have to have an active public assistance case, which is where there are no sanctions on the case. Not an easy thing. public assistance sort of designed to churn people through and get them sanctioned and make it difficult to request a fair hearing and lose your facts and get sued and those things. It's kind of snowball. Okay. Non-payment proceedings? We'll go with that. Okay. Okay. So we talked a little bit about, who is the petitioner who has brought this non-payment proceeding. Again, always really crucial to be checking who is the actual owner of the property. One caveat about the information on ACRIS is that it's about 3 months behind sometimes, so there could be a very recent change in ownership that's not going to be captured on ACRIS because the deed hasn't been recorded yet. However, you certainly can check the corporate owner, and you can double check the corporate ownership and whether or not it's pled correctly by checking the Secretary of State website for corporate registrations. And that will give you sometimes the principal information as well. Okay. Now what will often happen as well in a non-payment petition is that you'll have a respondent who isn't necessarily the person who's coming to you and saying they're the tenant, right? So you have the scenario, investor's client who was potentially succeeding to her brother's apartment. The lease was in her brother's name, but she was remaining in the apartment. Now that was a holdover case where they're saying she wasn't entitled to stay. But you might end up with a client coming in and saying, here's this non-payment case against my mother, but my mother died, 6 months ago. And I've been trying to get the landlord to put the lease in my name and I can't. That successor tenant would have a right to intervene in the non-payment case and assert their succession claim. And potentially satisfy the arrears, but then there can be all sorts of defenses to whose arrears those are, and who should also have been named. So if the deceased still had a lease, then the estate of the deceased, whether or not that person died with a will, should be named as a respondent. And that's some work for the landlord's attorneys. They don't like to do it because they have to go to circuit court. They have to get letters of small administration to get the person to get a community administrator, I think it's called. So there's often defects around that scenario that can result in a motion to dismiss being successful. And why would you do that in that case? Why wouldn't you just try to resolve it? Well, you certainly can, but if you filed a motion to dismiss and you've got leverage, now you can maybe resolve things in a more straightforward way. A description of the premises from which removal is sought. The address itself has to be properly pled. You may find, for example, a scenario where you have an apartment divided up. You have 3 people who are renting rooms within the first floor apartment, and they're sued as if, or one of them is sued as if they were the tenant of record on a lease, or they were the sole month-to-month tenant, and they're sued for as if the apartment was contiguous. And if you can bring in evidence that in fact it's been subdivided, then you may be able to get a dismissal on that basis as well. Or you may have a misdescription of the premises that has to do with just getting the apartment number wrong. Apartments, I had a case where the landlord called the apartment 911, and ironically, and it was apartment 9, and so the designation of the apartment is apartment 911, and the landlord did that because it had been a combined apartment at one point, apartment 9, apartment 11. But the misdescription of that apartment means that when should a marshal come to evict, they may be confused as to where to go to evict the tenant. And the tenant may be confused as to whether or not the petition refers to them in their apartment. So all of those things taken together results in an unamendable defect. Okay. The facts upon which the proceeding is based. Now this is sort of a big category which can include a lot of things. That's based in real property law, section 741. And it essentially relates back to the rent demand, which is a predicate notice and which can't be cured if it's wrong. So the rent demand itself is an essential condition precedent to a proper non-payment proceeding. It is almost always wrong, I would say. Probably 95% of the time it is wrong. And it may be wrong for a variety of reasons, but it can be worth bringing a motion to dismiss to, if the rent demand doesn't properly enumerate the breakdown of the rent, if the rent is in a lump sum, if there are other fees that are lumped together with the alleged rent that's due.
Are you taking questions?
Sure, I can take questions on that.
So I know there's all these technical things that you can make a motion to dismiss on and you could potentially prevail on if, the housing are receptive to case law, which I found not to always be the case, but what, in terms of resolving the situation, how likely is it in your experience that when you do a motion to dismiss that the case is immediately refiled properly, ostensibly, to the best it can be, the next time? And if it is, do you feel like having gotten it dismissed once does change the balance of power?
It can.
Enough?
It can. I think it's mostly useful for purposes of settling on the terms that you want.
Okay.
So I think it's mostly useful to give you leverage in a situation instead of letting that pleading defect go and just going in and signing a stip to pay by a date certain and
or consenting to judgment or worse.
Or worse.
So,
Right. You now have some leverage to bargain for things. So I'll withdraw my motion to dismiss on your pleading defect if you give us 45 days instead of 30 days to make the payment under the, under the agreement. Or if you agree that there'll be no final judgment, that we'll agree to, restore the case if there's a fault of the tenant in making the payment. And we're going to get to a section where we'll talk about the ideal kinds of things to have in a stipulation, but definitely motion practice is key to just changing that power dynamic. Okay. And that's what I think it's more valuable for. And what's my experience in terms of, where you actually see a dismissal through, or you might have an attorney who just concedes and says, look, you got me, I'm discontinuing. Okay, well, can they do that? They can do it under the CPLR only if it's within 20 days of the proceeding having been brought. So then you have some leverage to say, you can't just continue it without my consent, so you're going to give me something in this scenario. And it might be attorney's fees, depending on where you're coming from. And if the lease provides for attorney's fees. And that can be very powerful, It can get essentially the rent abatement that maybe you can't negotiate for one reason or another. You might be able to get the landlord to agree to cover your costs, your tenants' costs. Maybe you have working people who missed a day of work and are not going to get compensated. And the landlord can, give them $200 for discontinuing that case on consent. It's harder. It's easy for me to say that this is what you can do with something, and then to face, the kind of pitbull adversary who's, threatening you with going to trial, immediately and everything else. And we can talk about whether those threats are real or empty. But it's much easier to face that adversary when you've got papers in court and they haven't even done their opposition. Which is also going to be about 95% of the time, because it doesn't make sense for them economically to even write the papers. So now you've got an unopposed motion that's before the court on a meritorious procedural defense. It gives you some power. Okay. So we can talk just a little bit about the kinds of things that the kinds of mistakes the landlord might make that they're going to be able to fix. And there are a category of them, and there's a whole list, laundry list in your detailed outline. But for example, the kinds of amendments that the courts will allow are, for example, not having your multiple dwelling registration up to date. The court will be pretty lenient in allowing the landlord to obtain an adjournment for purposes of getting the multiple dwelling registration filed and not dismissing a case because the original petition didn't have the multiple dwelling registration active. Even the rent-regulated status of the tenant. So, that's kind of appalling, right? That you could bring a petition and get the rent-regulated status of the tenant wrong, claim that they're not rent stabilized, and then be able to proceed. The tenant has to show some element of prejudice, and it's possible that in that scenario that the judge would allow amendment of that defect. However, things like failing to put the court on notice of the regulations which are going to govern a tenancy, like certainly the regulated status does, but like the Section 8 status of a tenant is going to result in dismissal. And that's because there are additional requirements on the landlord petitioner, particularly if the tenant is a Section 8 holder through the NYCHA program, through the Housing Authority. So there's a federal lawsuit called Williams, Federal Consent Decree, that resulted from that lawsuit, which imposes on landlords additional duties to seek a certificate of eviction from the Housing Authority before proceeding to evict a tenant who is a Section 8 tenant holder. That certificate of eviction has to properly state what the tenant's share is. It has to not seek anything but the tenant's share of the rent, and the Housing Authority has to have responded. The Housing Authority is also supposed to be made a party to the proceeding, and that's often not the case. You can dismiss for failure to name a necessary party as well. Do you want to go to answering non-payment petitions? Okay. Okay, so who can answer a non-payment petition? The tenant of record, anybody who has arguably been made a respondent. So you may see Jane and John Doe in the caption, and a lot of my clients get offended by the Jane and John Doe thing. They're like, I don't know why that's there. There's nobody else in my apartment. Why are they naming Jane and John Doe? And it's obviously it's a way for landlords to try to catch anybody that they think might be in the apartment, any other co-occupants. However, if there isn't arguably anybody else who's been named as a respondent, there may, a person who's not the tenant of record may have trouble showing up to housing court and answering. And it's, I think experiences will differ amongst the boroughs and the clerk's offices, but while an occupant can certainly, and anybody claiming possession can certainly answer and has a right to answer in a holdover proceeding, it's not clear under the law that that's the case for a non-payment proceeding. Doesn't mean that that person who potentially has an interest in answering that case couldn't make a motion to intervene as a necessary party or someone who has an interest in intervening. More difficult to do, obviously, without counsel. So the mechanics of answering are that a tenant will get a petition in the mail, and probably personal service will be allegedly attempted, and then substitutive service of mail and mail, right on the door and in the mail. They'll be directed to come to court and answer. They'll go to the second floor of the clerk's offices, or the second floor in Brooklyn, wherever the clerk's offices are in your borough. They will be given a form which they either will check off themselves or the clerk will check off in hearing what their responses are to the petition. Now this is sort of, problematic because these forms often, when they are done by the clerks are kind of busy and they're tired and they're jaded and they check general denial. Yeah, you got the repairs, you got that, whatever, okay, general denial. And they're not necessarily going to go through and articulate every one of the tenant's defenses. Maybe they'll catch a few of them, but it's not going to be comprehensive. The tenant isn't necessarily knowing that that's something that they should really be looking out for. And there's frankly no space for counterclaims. So what kind of answer is that? That answer can and should be, when counsel's involved, be amended. It can be amended upon leave of court or with consent of the other side. So getting back to sort of this horse trading, it's very helpful to be able to go to court and say, look, I just got this case, I'm looking at this petition, I see X, Y, and Z wrong with your petition, we need time to answer or do a motion. And so you can waive certain things, right? You can say, well, my client didn't get the petition, she came to court because she got this postcard from the court, but she didn't get the petition. So what's happening there? You're raising personal jurisdiction. You're saying they were properly served. This tenant may be entitled to a traverse hearing. Traverse hearing is a hearing where the landlord has to bring in their process server with their logbook and take testimony about whether or not the service was proper. You can waive traverse as, bargaining chip for other things. So that's very helpful. Okay. On this outline, lack of subject matter jurisdiction is one of the procedural jurisdictional defenses. And it's kind of controversial, that's a kind of an old way to talk about it. And it comes out of a case, MSG versus Pump, where these kind of procedural defects in the notices and in the petitions were thought to be to deprive the court of subject matter jurisdiction because the subject matter jurisdiction of the court had not been properly invoked with the proper predicate notice. Okay. But the reality is, housing court has subject matter jurisdiction, right? Subject matter jurisdiction is about whether or not a court can hear a certain subject area. So it's not like somebody's coming and bringing a family court matter to housing court. It's appropriate in terms of subject matter jurisdiction. So I think it's sort of the phraseology has come to be called, egregious pleading defect, right? So these defects are egregious enough, and/or they're not amendable, and/or it's a predicate notice that can't be amended at all. And so I guess you should get away from that old term of lack of subject matter jurisdiction. However, there may be real situations where the landlord is claiming things they can't claim in a summary non-payment of rent procedure, right? So the landlord can't sue, for example, for air conditioning charges or electric fees or other kind of parking garage fees in housing court and try to evict you because you didn't pay your lights or you didn't pay your parking bill or you didn't pay your AC. And so that's actually kind of relatively common. And it's great to be able to dismiss those cases. The landlord is relegated to a plenary proceeding in civil court for those charges. And I guess I'll talk just really briefly because it's kind of an interesting subject. When you do these kinds of non-payment cases a lot, you see trends, right? And that's what I think makes this really interesting. And so one of the trends that many years ago now at this point, we were picking up on in Brooklyn is that tenants were getting sued for electric charges. They didn't owe any rent, and they were getting sued for their eviction for electric charges. And it was one of these big federally subsidized housing complexes, and it came down to an issue of submetering. So the landlords had gotten the Public Service Commission to approve a submetering order, which meant that now the tenants who used to have electric included in their rent had meters in their individual apartments and were starting to be charged separately for electric. Now, the Public Service Commission had prohibited landlords from turning off the electricity if the bills were unpaid, and so the landlord's only recourse to get that money paid was to sue tenants in housing court for it. And the reality was that was inappropriate to sue a tenant for rent in housing court. Now, there may be circumstances in which it is appropriate. You may see leases not for rent-regulated tenants, but for other kinds of tenants where separate kinds of charges are called added rent. And if the landlord has an added rent clause in their lease, they may be able to sue in housing court for added rent. What was happening, though, in this complex is that most or all of these tenants were also subsidized by Section 8. And so the federal government had defined what rent was. And rent under those definitions did not include utilities. And so the landlord's attempt to take something and call it rent was in conflict with the federal law that said, no, that's not rent. So it was a successful defense of very many people who were getting sued in housing court for not paying electricity bills. And there were other problems and other reasons why they were not paying the electricity bills, like the metering equipment wasn't working right, and they were getting greater dollar bills and things like that. Okay, so we talked already, I think, enough about rent demands. Misuse of pseudonym, Jane or John Doe. Sometimes the landlord will, not use the tenant's actual name, and will name them as Jane or John Doe. They have to show that they in fact don't know that tenant's name, so there may be other evidence that would support a motion to dismiss to show that in fact, you know, the landlord's agent has been up to the apartment, you know, 20 times in the last year and knows that the person's name is, you know, whatever, Jane Landry, and Jane Landry's name is on the mailbox, and Jane Landry has written the landlord letters, and that's another basis for a motion to dismiss. Okay. Oh, failure to have a certificate of occupancy. Okay. So a landlord cannot collect rent for an illegal apartment, essentially, right? So if you don't have a certificate of occupancy for a unit, you won't be able to maintain a non-payment proceeding against a tenant for that money. A tenant will not be able to reclaim any money though they've paid to the landlord for that illegal unit. That's kind of stinks, but it's in the property law. But they can stop paying at that point. Now what you're probably going to end up with is a holdover proceeding from that tenant who is going to be evicted from the illegal apartment, but in the meantime that person's going to be able to save what they would otherwise pay for rent. If the tenant was sort of had knowledge of that illegality and, you know, kind of worked with the landlord on that, then there may be problems in terms of their being able to claim that they shouldn't owe any rent. And in terms of certificate of occupancies, there's a date certain by which landlords have to have certificates of occupancies for their buildings. Buildings that were built prior to April 18th of 1929, there's no certificate of occupancy required. Where do you find a certificate of occupancy? You can go on the Department of Buildings website. You can put in the address. You'll get a building profile, and you can, if there'll be a PDF for the certificate of occupancy, you can check it out. It provides defenses for lots of things, like claiming that the building's not rent stabilized. You may have a building that appears to have 5 units, but in fact, you know, 2 of those units were combined. And at one point there were 6 units. And so, lo and behold, you have a rent stabilized tenant. So it's definitely worth checking that as well. Okay, lack of proper DHCR registration for an apartment. If you have a rent stabilized apartment, it is almost always worth getting a certified apartment rent history for that apartment. You know, the pressures that are of the real estate market are such that landlords are just incentivized to do all sorts of, you know, to engage in fraud. And so there is a 4-year statute of limitations on rent overcharge for rent stabilized apartments. It's a 2-year statute of limitations on rent overcharge for rent controlled apartments. However, there's a developing area of case law. The seminal case is called Grimm. It was a Court of Appeals case in which there was fraud in the rent history, and what happened was the landlord was essentially colluding with the tenants to bring the apartment out of rent regulation. And because of that fraud that was proven in the history, the bright line 4-year statute of limitations, which would have, you know, if you look back at what the base date was for the rent on that 4-year mark, it would have been a high rent. However, all of this fraud that had happened on this side of time was, you know, the parties could look at it, the court could look at it, and determining whether there was in fact a rent overcharge. And that concept of being able to look back beyond the 4 years when there's fraud involved is being extended to situations where you have tenants who, where it's not just limited to kind of collusion to bring an apartment out of rent stabilization. It's being extended to situations that are far more common, where the landlord is just fooling around with the rent history and alleging that there are improvements in the apartment that have been made, when in fact they haven't been, to get big jumps. False tenants.
One question.
That's okay, it's fine, Sally.
2 things. One, excuse me, DHCR registration, I tried to get it and I believe I was told I couldn't get it it could be mailed only to the tenant, but that takes a couple of days, and you have a short period of time to answer. Do you just go in person to get it, or you send a tenant?
You need to have, you can get it, we get them all the time, but you must have a release from your client that's specific to DHCR. So the release needs to say, I authorize you or your law office to obtain records from DHCR. So a general release won't work. You need it to say DHCR. You need the tenant's lease or some other indication that they are the tenant of the apartment, like a petition saying, I sue this person as tenant. And with those things, you should be able to, same day, obtain a certified apartment rent history registration.
So my second question was then it was, when I got one, it was significantly, the number that was officially reported when the landlord decided to report, register was 4 times as much as the rent that she was being paid. So
4 times what she was paying?
exactly.
So she was paying less.
Much less.
Much less.
So then there was a threat by the landlord's attorney that she would, have to be paying, she should really be paying $1,200. But so I assume that in that situation where you're gonna have this mismatch where in some cases it might actually favor, the tenant might be in a favorable situation by paying less, that would be a rent, if they raise the rent, then it would be a rental overcharge situation? Like if subsequent to the suit, they decided, okay, we're gonna actually raise your rent to what the DHCR rent,
It depends.
official registered rent is.
It depends. It
It's
depends.
complicated, okay.
What I suspect was happening there is that the landlord was alleging a preferential rent that I suspect, can't say with certainty without looking at all those documents, but I'm going to talk a little bit more about that. But a preferential rent is one where the landlord gives a preference to the tenant to take less than what they could take for the legal rent, because probably the market can't bear whatever that is. Now, there's lots of questions to be asked around that scenario, okay? Number one, is this alleged higher rent really accurate? And you would need to go back in the history to look at the percentage increases and whether or not there were turnovers of tenants and whether there are other tenants in the building who can tell you, no, Jane Doe lived there for 10 years. It wasn't a succession of 5 different tenants in that apartment. Clues that would let you know whether you can rely on that higher legal rent. And then you want to see the initial lease of that tenant, right? Because that initial lease may or may not indicate that it's a preferential rent. If this is a tenant who's been around for some time and had this preference for a long time, you may even have a situation where the language of that original lease calls that preferential rent as durational preferential rent, so that it's durational for that person's tenancy and can't expire at the end of the lease. There was a change in the law in 2003. And so it used to be that once you had a preference, always had a preference through the life of your tenancy, unless language in the original lease said otherwise. But there was a change in the law, and so there are lots of preferential rents being offered, particularly under these kinds of advantage and PEPS programs and things like that, which we may want that to happen, so we can talk about that, that will expire at the end of a year or 2 years, whatever the tenant has elected. And that may be legal. So, okay. I have no idea what time it is. Okay. I guess I'm doing okay. Answering non-payment petitions. Okay. This is kind of like the bulk of the outline, pages 13 to 31 of your outline. Okay, so you may have, defenses of partial or full payment of the rent. You may have landlords not properly crediting the rent. That's why, frankly, those rent demands are basically useless. You need the landlord to give you an in and out kind of rent breakdown that shows you when the rent came in, when the payment came in, how it's applied, and how this alleged arrearage came to be. Because then that will help you to identify whether you have other types of defenses, like latches. Maybe this is a rent accumulation from, 2005, and you have a statute of limitations problem because they're looking for rent that's more than 6 years old. They can't. Or you have, prejudice to the tenant in not moving to collect that rent for a very long time, thereby prejudicing the tenant by trying to have them come up with a large lump sum of money all at once. That's essentially latches suit. So, having a good rent breakdown will really help you to identify what this rent arrearage really looks like. You may have other things going on, like you may have the landlord trying to seek subsidy money that's not the tenant's responsibility to pay. We'll talk about that a little bit more too. Okay. Tender and refusal. A tenant who has tendered the rent can actually preclude the landlord from maintaining a non-payment proceeding. You could actually force the landlord to go to civil court to collect that rent if the landlord's tendered it and, the tenant has tendered it and the landlord has improperly refused it. We talked about latches. Warranty of habitability. Okay, so this is the, breach of warranty of habitability. Almost all the cases will have them, right? The landlord hasn't done what they're supposed to do to maintain the apartment in a habitable way. Certainly your answer wants to raise not only the defense of warranty of habitability, but the counterclaim of warranty of habitability, so that you can seek an abatement. And most the reason that raising warranty of habitability becomes so important in these non-payment cases, not only because this is a very, very important thing to your tenants and their quality of life, and because you potentially could get an abatement, although we talked about the practical realities of that. But more and more for rent-stabilized tenants, landlords are bringing what are called chronic rent delinquency holdovers. And they're alleging that the tenant has been so chronically late or delinquent with payment of their rent that they had to bring 5 non-payment cases against them in the last 3 years. And in doing that, they've breached their obligations as a tenant, and their tenancy can be terminated. It becomes really, really important then to raise the fact that you have defenses to that non-payment proceeding, which include warranty of habitability and other defenses, so that let's hope not, but if the tenant is faced with a holdover proceeding like that, you can go back in history and say, well, you may have sued me 5 times, but each time it was because I was holding my rent because conditions in the apartment were deplorable. Or you sued me for the Section 8 money, which I wasn't supposed to pay anyway. So really articulating in an amended answer all the possible defenses a tenant has is becoming more and more crucial. Okay. I already talked about Williams. Okay. Talked about the Section 8 tenant not being liable for anything but their tenant's share. Now that's true even after termination of the subsidy. So a tenant could lose their Section 8 subsidy for a couple of different reasons. Maybe the subsidy has been terminated because the apartment can't pass inspection. The apartment will fail inspection, and if it fails inspection and the landlord fails to make the corrections within 30 days, the subsidy will be suspended, and if it stays in suspension for 6 months, the Section 8 subsidy will be terminated. And we now use that phrase terminated because, in fact, the HAP contract, the contract between the landlord and the PHA, Public Housing Agency, whether it's HPD or NYCHA, does terminate. And so there are policies which allow the tenant to get the Section 8 restored or to move with an emergency transfer voucher. But the tenant could be legitimately in a terminated status, facing a non-payment case, standing in front of one of our judges who's maybe not as well versed in the law as you are, and the landlord's attorney is saying, they're terminated, Your Honor. They owe the full contract rent. There's no subsidy being paid for this apartment. And how fair is that? That the apartment was disgusting, and that's why they lost the subsidy, and now they're potentially, they're facing an argument from the landlord's attorney, although it's improper, that they owe all the rent. Many, many, many tenants signing agreements to move out of their apartment because they think, or signing agreements to pay $8,000 in 30 days because they think that they owe the money, and they don't. They will not only be evicted, they will lose the Section 8 voucher as well. So these cases are really important. Okay, let's see. Okay, also in these federally subsidized buildings, there are procedures for recertifying the tenant for their income subsidies and notices that go out to the tenant when they have maybe not complied with recertification. So the tenant, the landlord alleges, okay, your rent is now $1,500 because you didn't come in for your recertification and we sent you 3 notices. Well, they have to prove they sent those notices, and the notices have to be adequate under the provisions of the federal law for the landlord to be able to charge that market rent, and there are often defenses in that notice string because they screw it up all the time. And you can get discovery in that case. So that's a kind of a non-payment case where you would want to make a motion for discovery because you're going to be able to get that information that's solely in the landlord's hands. How are you going to prove that otherwise? The tenant says they didn't get the notices. They don't have anything to show you. Okay. Scree and DREE, do people know what that is? Mm-hmm. No? Okay. So another kind of subsidy, in a way, is the Scree and DREE programs. That's Senior Citizen Rent Increase Exemption or Disabled Rent Increase Exemption. What it is a tax abatement credit for rent-regulated tenants and some Mitchell-Lama tenants as well, to cover rent increases. So if you're 62 and you have a household income that's less than $29,000 a year and you're rent regulated, your increase at the time that you apply will be covered by a tax abatement credit to the landlord. So you don't have to pay those increases, you get frozen, and if for some reason the landlord doesn't get his tax abatement credit and sues you for it, that's a dismissible case. There are other income eligibility guidelines which are lower for the DREE program. Both the Scree and the DREE program are administered by the Department of Finance. So you can go on the Department of Finance's website for applications and frequently asked questions and that kind of thing. Okay. Rent deposit order. Kind of, thank God this doesn't really get enforced, but there is a provision of the RKFOL which can require, if the landlords make a stink about it, a deposit of the rent in dispute, not the undisputed amount, to the court. And of course, that would just mean that tenants would not be able to, defend their case. Fact is, it just doesn't get. It's kind of more of a pain than anything else, and I think that landlords just don't seek it, but it's there. It lingers. Okay. Okay, we sort of talked about overcharge and damages for breach of warranty and habitability. Real property law 235A offset is maybe a scenario that some of your group HP tenants would face. They have a landlord who's kind of abandoned responsibility for a building. He's not paying the electricity. He's not paying the gas. Tenants Association can step in, or an individual can step in and make payments and then deduct it from rent that is owed. And that's a defense, obviously, in the non-payment proceeding. And the question about repair and deduct also, I think it's an attractive option to tenants. It feels very powerful to be able to say, I'm not paying you a dime of my rent until you fix the hole in my ceiling. And fortunately, I think it's not a position that tenants attorneys, advice tenants attorneys like to give tenants. And I think it's because of the danger of getting into that sort of dynamic where you're the one who's on the defense, right? So now you're the respondent in a non-payment proceeding. Not only are you going to have to go through, probably without a lawyer, the kind of emotional wrenching of being told that you're a deadbeat because you haven't paid your rent. You're probably not going to get the satisfaction of a rent abatement without counsel. You're probably not going to get those repairs done in a timely way. And you may face also the fact that there's now a proceeding that's been brought against you for non-payment of rent that gets reported to some kind of tenant credit reporting agency. So now you have to explain yourself when you go to apply for that next apartment. Why did you get sued and not payment? So we advise tenants to bring HPs, and we advise tenants that that's a much more effective way to seek the relief they need for the repairs. It doesn't get you the abatement, However, I was actually going to ask you what your practical experience was with HPD attorneys. I have had the situation where I've brought HP proceedings for tenants who owed rent, but before a non-payment was brought, and I've been able to sort of horse trade civil penalties for the tenant. So HPD will threaten the landlord and say, look, you know, we've got civil penalties. How about you write into this HP stip that you're gonna, you know, give them 3 months rent. Or, I mean, it doesn't happen all the time, but it can, especially in an egregious situation. Okay, motions, discovery, stipulations. Okay, so we talked a little bit about motions for discovery. It's an ample needs standard. You have to show that the other side has documents that are, you know, exclusively and uniquely in their possession and not in yours. You may, in that scenario where you're looking at a rent history and you see that the landlord's claiming that there were improvements made between the last tenant and this tenant, you may make a motion for discovery to see if you can get the landlord to produce these phantom, you know, receipts. Now, they may make them up, or they may not be able to produce them, in which case that can be helpful to your defense of rent overcharge. You may also seek interrogatories. So there's certainly different kinds of discovery that you can use. You can seek interrogatories from experts. If you've got, I had a case where, well, this is a whole different case, but I could potentially see it in a non-payment case too, where a tenant had done her own renovations to a bathroom, and the plumber had, the landlord's plumber, you know, the basis for the landlord's petition was the landlord's plumber's examination to say that various things were not done to code and etc. So I was able to move for discovery and get the expert's report, you know, sort of enumerating what they were going to claim these alleged building code violations were to help me prepare for trial. Okay. So we talked a little bit about, you know, what kinds of things do you want to have in a stipulation of settlement? You know, many of these cases are going to settle with stipulation, right? Most of these non-payment cases are going to settle with stipulation. I have actually another gift, which is this outline, so I'll pass along, that was written by our Director of Litigation at South Brooklyn Legal Services, Ed Josephson, and it's got some sort of tips for, you know, what you want to do or not do in a stipulation, and it also has with the rationale for why, and it also has the sort of sample stipulations at the end. So here's a good form stipulation of settlement without a final judgment, and here's one with a final judgment. And you know, what's the difference between a final judgment and having one and not having one? Obviously, it's the, you know, immediate and imminent threat of eviction should there be default. So you're, in most cases, going to be trying to assist the tenant to get some kind of relief to pay rent arrears. And you're going to need as much time as possible to do that, because you're interacting with HRA, Department of Social Services. You may have to, you know, get a whole lot of applications together for charitable assistance. There may be lots of bumps along the road in actually meeting payment. And if you have not agreed to a final judgment, if there's in fact you don't meet your pay date, the landlord will be forced to bring the proceeding back to court on motion, thereby giving you more time, thereby giving you, you know, an opportunity to put in more papers to say why their request for a final judgment of possession against your tenant may not be appropriate. Maybe what's happened is that the landlord has essentially interfered with your ability to meet the terms of the stipulation, and you have a sort of unclean hands doctrine to raise. So there are lots of reasons why you want to try to avoid a final judgment. Sometimes it's just unavoidable. You know, you're representing the tenant, there's already a final judgment, maybe because they've entered into a pro se stipulation. We can talk about vacating those. Or you're just, you know, you're at the 6th adjournment of the case, and the landlord's patience is, you know, waning, and you're not going to be able to get them to agree without agreeing to a final judgment. And, you know, so what happens if you don't settle the case on the day that you're going to court? And they don't have a pending motion, and there isn't anything else that's going to delay the case. Well, potentially you're going to trial, right? And potentially you could have a very quick determination from the court that your client owes X amount of money and has 5 days to satisfy that after a judgment. Now that's the kind of classic intimidation tactic of the landlord's attorney, right? I'm sure many of you have heard the tenants you work with come in and say, they told me I was going to be evicted in 5 days. You know, what's the reality of that? The reality of that is, you know, it's a danger, but the practical reality is there's probably not a trial judge available that day. You know, you could kind of stall for a while and maybe not get sent out to trial that day. Maybe you could get before the judge and request an inspection, and then that will adjourn the case. So there's lots of things that a tenant can do to slow down the train, but they don't know that, and they don't know that when they're pro se. But we know it, and so this isn't something that should intimidate us. Also, the fact is that what if you did get sent out to trial? You know, you still have your defenses, and what if you do get a judgment that says pay this in 5 days? Well, we have, you know, and certainly we collectively have those resources to get emergency approvals, right? So we could go to the rental assistance unit at the Department of Social Services and say, I've got a final judgment after a trial, we did our best, we got a 20% rent abatement, but she still owes $5,000. She's going to be able to pay this if I can get her FEPS, but we need to get this approved right now. You can do those urgent kinds of, you know, maneuverings. So, you know, you have to take those threats, you have to know the context so that you don't feel intimidated by those threats. Okay. Some of the things that you'll find in this outline that talk about what's helpful to have in the stipulation, you certainly want to have a complete rent breakdown. So, you know, a stipulation that's like 3 lines that says, you know, pay $5,000 by May 30th and, you know, no repairs is not a great stipulation, right? And that's true for a number of reasons. Number one, because there may be payments that are pending that the landlord hasn't yet credited, that you want to make clear are out there, and that this number doesn't reflect those credits yet, so that you don't have an argument later about when they come in about whether or not those should be deducted. You have, particularly if you have tenants whose source of shelter payment is from public assistance, excuse me. You also want to really kind of map out for the court now, more than ever, your efforts, what your plan is for getting this money paid. And that's because of a case called Chelsea, which is a case that went to the appellate term and basically denied an order to show cause of a tenant on the basis that they had no good cause for any further extension of time after a final judgment had been, after satisfaction of a final judgment had been met. And essentially, you know, I think people sort of overreact a little bit to this Chelsea case and are worried about it. However, it is obviously good practice to get as much evidence in the record as possible. If you have to go back and do an order to show cause because you haven't met the final judgment payment, you want to be able to show, you know, my efforts were, my plan was, we're applying for FEPS, we're applying to charitable organizations. You know, the landlord is going to cooperate with the respondent's counsel by providing its taxpayer ID for an ACS subsidy. An ACS subsidy is Administration for Children's Services. There are certain housing subsidies for people who have open ACS cases. You know, it sometimes requires a landlord's cooperation, and so documenting that. You know, the landlord has to provide a corrected rent stabilized lease to reflect succession. Not going to be able to get that one shot if you don't have a lease in your client's name. Documenting those plans will make the, and also including in that stipulation a consent to an order to show cause. So the landlord consents to the tenant bringing an order to show cause for good cause shown. Makes it easier when you go to file that order to show cause. The judge feels they have something to hang their hat on and not so worried about, you know, whether or not you deserve this order to show cause, this extension of time. Okay. So you may have tenants who come into you and they have defaulted on a pro se stipulation of settlement. The standard for vacating, you may have tenants who have a default judgment against them. So they missed the initial court date on a holdover, or in a non-payment case, they never answered the petition, and so they defaulted. That In that scenario, you're going to have to show good cause for defaulting, for the tenant not having gone into answer or being at the court date in a holdover, and that you have underlying meritorious defenses, right? So, service is a classic example. You know, the tenant who got the postcard and didn't get the petition, that's good cause for not answering. Meritorious defenses, warranty of habitability can be just that, as a meritorious defense to non-payment. And in terms of vacating an unfair stipulation, the tenant who has agreed to vacate their rent-stabilized apartment in a non-payment case, converting it to a holdover, the tenant who has agreed to pay $8,000 in 30 days that was really Section 8 money. Those are, the standard is sort of one-sidedness, an unfairness, a waiver of rights that one didn't know one had. And that standard will get an order to show cause signed and a judgment vacated. Okay, so do you have experience with this sort of one shot, and what does that mean, an exception to policy, and would you appreciate a little discussion of that? Yeah, okay. All right, so a one-shot deal, as it's called, is a term for assistance from the Human Resources Administration, aka welfare, to help with rent arrears on a one-time basis because of a crisis that the person can show reasonably they got into the reason why they got into their rent arrears, and that they're going to have the future ability to pay their rent. Generally speaking, you know, now tenants are being told you only get a one shot if you're working. That's not really true. Okay, so there is a kind of semantic difference between a one-shot deal and an exception to policy deal. So if you're currently on public assistance and you need rent arrears help because maybe you just got on public assistance and you, in the 6 months prior to that, had lost your job, exhausted unemployment benefits, and couldn't pay your rent, but now you're on public assistance and you're not eligible for FEPS maybe, but you have a sister who's going to be able to help you pay the difference between the shelter allowance and your rent, whatever it might be, that rent arrears grant would be called an exception to policy. So the policy is that at the center level, a public assistance tenant can have 4 months worth of rent paid. Anything more than that is going to be an exception to policy. A one shot is somebody who is not on public assistance. Okay. So, you know, that process is really tricky, but, you know, this community, you should reach out to us, those of us in legal services and elsewhere that have connections with the centers, with the supervisors that you send things to directly. I mean, you know, your client at the bare minimum has to go in and make the application at the center themselves. But thereafter, you don't have to deal with the caseworker and whether or not the caseworker is going to approve it and send it on to their boss. You can deal with their boss directly. And that's what we do. We communicate directly with the rental assistance unit. We get approvals, we get them quickly, and they know that we're working on urgent situations, and so we usually can get things expedited. And we make huge differences for tenants in other situations where tenants have been approved for a grant, didn't know it, and have been doing 2 or 3 orders to show cause, telling the court, I don't know what's happening with my one shot, I think it's being approved, it's pending, and then at some point the judge says you've had too much time, you can't show me anything that says that you were actually approved for this. We've had tenants be evicted, but they had the approval, and they just didn't know, you know. So, I mean, being able to sort of cut through the red tape, also for an attorney, maybe not strictly legal work, but really, really important. Okay, to apply for FEPS, you actually have to go through a FEPS provider. So again, as an individual practicing attorney, you would not be able to do that. You have to go through legal services, legal aid, some other organizations like Canva and Brooklyn. And that's something, again, if you email me, and I'll tell you who the FEPS providers are.
Just a quick question.
Sure.
One shot, is it a grant or does it need to be repaid?
It does need to be repaid for the most part. Repayment agreements will have to be signed. Whether or not it has to be repaid, I can talk about the practical reality of that. But if you are at or below 125% of poverty, it does not have to be repaid.
Oh, cool.
You'd be amazed at how many people are above that, though, and are still in poverty, obviously. So in terms of the practical reality, you know, HRA doesn't bring loads of these collection cases, but they do bring them. You know, so they'll send scary notices to your client, like, you know, you've agreed to pay $400 a month until this is paid off. And, you know, people have done that and not paid their rent. Obviously, that's not the wise move, you know, because what's the result if you don't pay that HRA grant? So they go to court and they get a money judgment against you that they execute against what? You know, I mean, if you're working, they would execute it at 10% of your earnings potentially, but it's a 10% payback on the loan, as opposed to being evicted for not paying it, right? So, and some of those cases just don't get brought. Okay, I know that I'm running over. Should I keep going? All right, I'm very close to done. We're at post-judgment stage. That's got to be encouraging, right? All right. Okay, staying the warrant of eviction. Okay, so the real property law provides the court with the discretion to vacate a judgment for good cause shown under real property law 749(3). So that can mean vacating a STIP. It can mean vacating a default judgment, even after, before execution of the warrant, even after execution of the warrant. The court under real property 747A shall not grant a stay unless the judgment amount has been deposited with the court. This provision of the law has actually been examined in both the first and second department, and there's a split about the constitutionality of that law. The first department says it's not unconstitutional to insist on a 747A deposit of the judgment for further stay. The second department says it interferes with the power, the discretion of the court under 749(3) to vacate a judgment and to change the terms of its own order. And so the power of the court to use its discretion to stay a warrant of eviction, or even to put somebody back in an apartment post-eviction, remains good law and is in fact regularly exercised. I do think, though, in light of Chelsea and other cases, that it really is incumbent upon us to really make a good record on orders to show cause. So when bringing an order to show cause or in supplementing a pro se order to show cause, to have a really detailed affidavit that examines what the efforts were along the way prior to the default on satisfying the judgment to seek the monies. Okay. All right, I think that's clear enough. The last thing that I have to say is that, you know, again, even after eviction, CPLR 5015A allows the court the discretion to vacate its own judgment in the interest of substantial justice. So again, the discretion is broad. There's a substantial justice argument, you know, long-term tenancies, elderly people, disabled people, equitable facts, newly discovered evidence. Those kinds of things are going to help you to be successful in that scenario. We didn't even touch the sort of what you do when you have a kind of incapacitated client and guardians ad litem and all that, but those things can come into play in these cases as well. So it's a lot of substance. It really is. As I said, each of these kind of areas could be its own training. We didn't get to this exercise, but what I'm going to do is I'm going to pass these out. What it is a kind of form petition, non-payment petition, and a form answer, just in case you haven't seen them, so you know what they look like. Okay.
And Jane, we got started a little late, so if you wanted to take a few questions, we can
Certainly.
technically still have time for that within
Questions are great. I love
the CLE full time. So.
Sure, absolutely. Do you have any more questions?
I mean, I always do, but I would like to give other people.
Okay.
Well, you were speaking earlier about how you see things in trends with landlords. I was wondering
I'm
if
sorry, I
there's
didn't hear you. How what?
you spoke earlier how you see trends when it comes with the
Yeah.
mills.
Yeah.
Is there any trend that you see developing right now that we should be aware of?
Right now. I think, you know, the most egregious is the sort of rent overcharge and like looking at these programs where, Advantage tenants had leases for rents that were way in excess of what the legal rents were. Not all of them, some of them had rents that were less than what the legal rents were. But that kind of, pattern of abuse and rent overcharge, I'm sort of seeing a kind of uptick in. For a while there was like a whole spat of owner use holdover cases, and then we, were dealing with holdover case. Well, for a long time we were dealing with Section 8 cases where the landlord would claim the tenant was terminated, and because they were terminated, they owed the full rent. We kind of beat that back with lots of good decisions that made it clear that was not the case, but they're still there. It's amazing to me that, again, as I said, like, you look at a petition, and if you're a housing court judge and you don't know from this petition that in fact, in this example, in this case, this tenant had Section 8. Nothing in the petition tells you the tenant had Section 8. The tenant's share was some $200 less than what the landlord claimed the legal rent was that she was responsible to pay. If I'm a housing court judge and I'm looking at this petition, all I see is that there's a bunch of arrears, that it's rent stabilized, $979, that sounds reasonable, that doesn't sound like a hugely high rent. She got served with the petition, okay, and she signed a stip agreeing to pay the money. Ordered, so it's digging behind all of these elements to, identify what's really going on with the property. And also, what's interesting is when, it's very difficult when you're pressed for time, but finding out from tenants what's going on in the building, right? I mean, we're talking about sort of these larger issues of organizing. Are there other tenants who are getting eviction notices? Oh, really? There are 5 of you in court? Wow, okay. And, so why is that? Oh, there was a change in ownership? Okay, and, these kinds of things sort of like build. And you see trends.
So if you want to make a rent overcharge claim to DHCR and you don't have a housing court case, so
Right.
everything's going to be decided on the papers, right, with DHCR.
Yeah.
So if you want to get information about like a claimed individual apartment improvement and other alleged improvements in the building, how would you go about getting those?
Yeah.
Do you like foil DHCR, because would the landlord have had to have filed all of that with them? Is that the way
There's
to
no
get it?
requirement to file it until there's a challenge to it.
Okay.
So you would get it because you filed the rent overcharge claim with DHCR, the landlord answered and attached their evidence.
Okay.
The problem is that it's an administrative proceeding where you don't have a right to a hearing necessarily. You're not going to be able to cross-examine the landlord, or you can only kind of poke holes at these receipts. I mean, I really think that where you can bring an affirmative rent overcharge case in the Supreme Court, so you can get discovery and you can really dig around. It's a good thing to do. I mean, you have to feel fairly confident that you've got something to do that, right? But you may end up with attorney's fees too. And having that original lease can be crucial to deciding where you're going to end up going. Having a filed rent overcharge claim at DHCR can be helpful if the tenant is then sued in a non-payment case, because you can try to move for a stay of the eviction proceeding based on the previously filed DHCR case. In one of these cases where I defended a superintendent who had been terminated, he was also a rent stabilized tenant. The landlord claimed that his rent was over $2,000. He had always paid $500 based on an initial lease he had when the building was in receivership. He brought a DHCR complaint and rent overcharge, which we ended up withdrawing because we realized we needed to depose the receiver who had given him the original lease, and we weren't going to be able to get discovery in the rent overcharge claim in DHCR. But not before we got the housing clerk to stay the proceeding based on the DHCR rent overcharge. Then we withdrew it, and then we filed in federal court. So it was fun.
Can you just repeat what the term was? You said not subject matter jurisdiction, but there's a
Egregious pleading defect. Egregious pleading defect. Yeah.